The law in Arizona as it applies to cases brought by junk debt buyers like portfolio recovery associates is somewhat in flux, and this has resulted in rulings from the various courts that can really be all over the place. Often the end result of your case will largely be influenced by the judge you get or whether your case is in justice or superior court. However, as I've tried these cases over the years, there are other more indirect ways to win your case against portfolio recovery associates or any of the debt buyers. The first is to show up on time. I've won more cases than I'll likely admit by just showing up to the court hearing on time, particularly in the justice court. Throughout the timeline of your junk debt buyer lawsuit, there will be various hearings that you'll be required to attend. Often, if a party does not appear at one of these hearings, the court can either enter a judgment or dismiss the case. Now, the attorneys who represent debt buyers have a lot of cases. They file thousands of these a month in Arizona. And almost all of the law firms that handle these cases are comprised of a handful of lawyers and a bunch of paralegals. This means that they're very busy, and many times they either don't show up or they're late to a hearing. If you're standing there at a trial or a pretrial conference and the attorney for portfolio recovery isn't there, ask the judge to dismiss the case with prejudice, meaning they can't file it again. The courts are busy, and if a party doesn't show up, most judges won't hesitate to throw a case out. Now, take note, this works the other way as well. If you don't show up or you're late to a court hearing, you could end up with a judgment against you before you ever even have a chance to put up a defense. Number two is to object to their witnesses appearing telephonically. Now, when portfolio recovery associates or any of the other debt buyers go to trial, they're going to need a witness to introduce their various documents into evidence. Now, these witnesses are always associated with the debt buyer, if not directly employed by them. They usually don't live in Arizona, and the debt buyers certainly don't want to fly them out for your 1-hour trial. So their solution is to ask the court to allow the witness to appear over the telephone. Arizona law requires that witnesses appear personally at trial to give testimony. However, it does give judges a little bit of wiggle room to grant a motion to have them appear telephonically. Object to this motion. There are all kinds of reasons. You can tell them it makes it hard to review the documents with the witness who's on the phone. You can't see the body language of the witness. You can't ensure the integrity of the trial because you really don't know what the witness may be looking at, etc. The key here is to fight it. If you can get the judge to deny the debt buyer's request to have their witness appear over the phone, the case is over. I handle these cases day in and day out. I've only had one trial where the debt buyer flew a witness in, and that was where there was more than $30,000 at stake. If the court denies their motion, you win. They can't proceed without a witness. Number three is to ask for mediation. If you can settle your case for a lowball amount, I still count that as a win. Often when people get wrapped up in this litigation process, they forget that you can still win your case by getting out of it for a small amount, or at least smaller than what the debt buyer is seeking. In Arizona, there's only one court in the Phoenix area that requires mediation in all cases. That's the McDowell Mountain Justice Court. Now, mediation, sometimes called a settlement conference, is where the court assigns an independent third party, or a mediator, to get with the parties and see if there's some middle ground that can be reached. Now, many times the attorney for the junk debt buyer will come into mediation with no real expectation that the case is going to settle. A good way to catch them off guard a bit is to come in with some kind of settlement offer. Offer 10% of what they're suing for. If you can pay it, you might be surprised how many times a junk debt buyer will bite on this kind of offer. It's important to remember that dealing with the junk debt buyer directly, like you did before they sued you, and now dealing with their attorney are two totally different things. The attorney is looking to get another case off his or her desk and may be willing to settle the case for much less than the junk debt buyer would. If you can get out of your case for 10 to 15% of what they're asking, you should take it. That's a good deal. And it's low enough to more than offset the risk that you would encounter anytime you go to trial. You need to remember that trial's an all or nothing proposition. If you win at trial, you pay nothing. But if you lose, you pay everything. And now the debt collector has a judgment and they can garnish your wages, levy your bank accounts, and lien your property. One other quick note on mediation. If the attorney for the junk debt buyer doesn't show up, or if they show up and a representative from the junk debt buyer isn't with them, ask the mediator to default them. And then you can ask the court to dismiss the case as well. On more than one occasion, I've had the McDowell Mountain Justice Court dismiss a case because the attorney and a representative of the junk debt buyer didn't show up to mediation. Sometimes they'll try to get around this by filing a motion to permit the junk debt buyer's representative to appear over the phone. Again, object to this. If you have to be there, so should they, not just their attorney. My point is that there's more than one way to win these cases. Don't get discouraged because court rulings are all over the place. This is one instance where participating in the process and simply showing up can pay big dividends in the end. Thanks for watching.